Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and we let you do the rest. All right, we're back today, May 16th, with a Supreme Court decision, A.A.R.P v. Trump. This is the one that you guys have most likely been hearing about in the news, so let's get into the facts of the case. So this one deals with a legal challenge brought by two detained Venezuelan nationals identified as members of TDA or Tren de Aragua, which, as you may know, has been currently classified as a foreign terrorist organization. The case also involves a group of similarly detained individuals that are represented as a group within the actual case. And all these people together sought to stop their immediate removal from the United States under the Alien Enemies Act. The core issue of this case is whether these detainees were given adequate notice and opportunity to challenge their removal as required by the U.S. Constitution's due process protections. More specifically, the 5th and 14th Amendment, which basically both say no one shall be deprived of life, liberty, or property without due process of law. All right, so let's get into the backstory so we can understand what's going on today. This all started when the president issued a proclamation under the Alien Enemies Act to remove Venezuelan nationals identified as Tren de Aragua members. The applicants identified in this case were held in U.S. detention facilities in the Northern District of Texas, and they argued that their planned removal violated their constitutional rights because they were not given notice or chance to challenge their removal. So, the detainees requested a temporary restraining order to stop their removal, but this was denied by the district court in Texas. After this denial, reportedly hours later, the detainees claimed they received notices saying that they were to be deported, quote, tonight or tomorrow. So, the detainees in response to that filed an emergency TRO, temporary restraining order, request and demanded a hearing and ruling that day. The district court did not act by the requested deadline, so the detainees appealed to the Fifth Circuit Court of Appeals, claiming that the district court's inaction was effectively a denial of their request, so therefore they were able to appeal it to the Fifth Circuit Court. The Fifth Circuit, in response, dismissed the appeal, saying that it lacked the jurisdiction because the district court had not formally denied the TRO. The detainees then asked the Supreme Court for an injunction, a court order to stop the removals, while the legal issues were sorted out. And this is when the Supreme Court stepped in and basically said, hey, let's just calm down, let's push the brakes, put a pause on this whole process so we can have time to review the Fifth Circuit's decision. And this is where we get to the point that I want to emphasize passionately. In this case, the Supreme Court did not, I repeat, did not rule on whether the deportations under the Alien Enemies Act were lawful or not, which people are already claiming that is what happened. So make a note of who's telling you that and maybe be a little skeptical of them in the future. What the Supreme Court was in charge of reviewing was whether the Fifth Circuit's dismissal of the appeal on the emergency temporary restraining order was the correct decision. And in a 7-2 ruling, the Supreme Court said that the district court's failure to act for over 14 hours in the face of urgent circumstances amounted to a denial of the injunction, which means that the Fifth Circuit, and by extension the Supreme Court, does have jurisdiction to review the case. The court also emphasized the Constitution's Fifth Amendment that guarantees due process for non-citizens in removal proceedings, saying that the government's 24-hour notice, lacking details on how to challenge the removal, was insufficient under the Fifth Amendment. So, what happens now? The Supreme Court has officially vacated the Fifth Circuit's dismissal and granted a temporary injunction to stop the deportation of these detainees under the Alien Enemies Act until the Fifth Circuit Court resolves the case. The case will now be sent back to the Fifth Circuit to determine whether the detainees are likely to succeed in arguing that the Alien Enemies Act doesn't allow their removal and what kind of notice the detainees are entitled to under due process. Again, the court made sure to clarify that it was not deciding whether the Alien Enemies Act removals were legal overall, only that the detainees deserved better notice. Also, a major point we need to understand here is that the government can still deport these individuals under other legal authorities. But while this particular case is pending, they cannot go about that process using the Alien Enemies Act as justification. All right, a lot to unpack there. Hopefully you guys stuck with me. Good to go. Remember, Kaimo, keep your mind open, do your own research, form your own opinion. See you on the next one.